Seven, eight, nine are connected. So when do you want? We can try on 23rd. 23rd. On a request made by Sri K. Agarwal, learned senior counsel, appearing for the appellants in which case? In one of these appeals, comma, the matters are adjourned to be listed on 23rd, 23, 4, 7, 8, and 9. Okay. 23, 4. Okay. 23rd, yes. That is a Thursday. Okay. Yes.
Before the mediation, and it was the appellant wife allowed to withdraw that.
Okay. Bring it. Tuesday or Monday, whenever you say. It will come for hearing.
Life.
You have it for
12-year sentence.
Mr. Ahmed, you have it for orders. Tomorrow we'll fix a date of hearing. Okay. Hearing date didn't know. Monday. Yes. Well, okay. On a request made on behalf of the appellant, matter is adjourned to be listed after the Bihu vacation. Yes.
Item 12, supplementary.
Yes, you want to mention something? Yes, which one? Yes.
Item 12, supplements.
By a family court. By a family court. You have entered appearance for the respondent. Okay. We can have it for admission hearing whenever you want. Since you have appeared, and it will be on the basis of whatever has been on the materials which were considered by the learned court. Huh? No, you have, I think you have already, you have given all the materials. There is no requirement of calling for the records. Yes, Mr. Ali.
This period under 120 proceeding period. As per our family courts act, my lord.
Yes.
Taken by the seeking concern.
That is one issue we have.
Because this is not a matrimonial dispute.
No, it's not a question of matrimonial dispute. See, chapter 9 has two components. One is an appeal, one is a revision. So far as appeal is concerned, there is a specific subsection that it has to be heard by a bench of not more than, not less than 2 judges. But that specification is not there for subsection 4, which deals with revision. Correct?
But we have a notification of the registry.
Yes. No, we have had the occasion to consider this notification. This notification perhaps has not has overlooked this aspect. It is only if an appeal which is required to be heard by a DB. Because we cannot go beyond the statute. Statute says, prescribes. Allowed to experience tribunal appeals matters.
The spirit is correct of the notification because all matters since that's for some reason appeals are heard by division.
See, either way, you do not suffer any prejudice. This is not a writ petition that an appeal lies before a DB.
That is a
No, it's a
disadvantage.
revision. No, it's a revision. See, it's appeal. There is a bar because chapter. If you take the Family Courts Act, see, it's chapter 9, the
90 days.
section 19. There is a specific bar that all matters which are under chapter 9, no appeal shall lie. So 125, 126, 127 comes under chapter 9 of the CRPC. So the only recourse you fall back is 19.4, which is the power of revision.
90 days.
Though this chapter 5 is, though this section 19 only talks about appeal in the heading, it's under chapter 5, which is appeals and revision. There is no separate power for revision. It is 19.4, which Mr. Podar is trying to invoke, and rightly so. It's only question who will hear this. Now, if a single judge hears, then also if you are aggrieved, you cannot file an appeal in this court. So it doesn't make any difference. So let us hear this.
The maintenance.
Okay, when can we hear it? When can we hear this? We'll have it for admission hearing, small matter. Next Thursday. Okay. Heard Sri S.K. Podar, learned counsel for the petition. I also heard Sri R. Ali, learned counsel for the sole respondent. The revision petition is against an order passed under section 127 of the CRPC, which would require an expeditious consideration. Full stop. As agreed to by the learned counsel for the parties, list for admission hearing on Thursday. Date.
Item 13.
Item 13. I has been allowed.
For the victim side.
Okay. We'll admit this. Part 3 P.P. Bodhakur, learned counsel for the appellant who has preferred this appeal against so-and-so, by the impugned judgment, the accused persons have been acquitted. 1 person or 2 person? Accused person has been acquitted. Admit, call for the records. Mr. Kaushik, R. Kaushik for 1, additional PP. Steps for service. Why have you? Okay, the steps for service of notice upon the respondent 2 in the usual manner. List after 4 weeks for a report on receipt of records as well as service upon the respondent 2.
Item 1.
Yes. upon file record. No, you had taken dusty service. Then did you file the affidavit? Hmm? Then the entire exercise will go futile. You said that you want to serve dusty. It was allowed. What is this petition about? Then you take fresh steps. Without hearing. Without hearing, how do you dispose? They have not even been served. Notice is not found, taken to the if the respondent has refused to accept, you file an affidavit that it was refused to be accepted. We will pass an order of deemed deemed service. Then we can proceed. Then you file an affidavit. Your name? Sri M. Hussain, learned counsel for the petitioner, has renewed his prayer for grant of additional time to file the affidavit as required vide the order dated 13/3/2026. Para, we accordingly grant 3 weeks further time to file such affidavit. Full stop. List on 22nd of April. You filed the affidavit, state that it was not accepted. Okay.
Item 14, supply list.
Records have been received. I see. No, that direction can be given only after receipt of the paper book. That is it. We are passing the direction now. Heard 3D Gogoi, learned counsel for the appellant, also heard 3 R. Kaushik, learned additional PP Assam. Full stop. 3 A. Ahmed, learned counsel, has appeared for respondent 2 as amicus curiae. Full stop. Pursuant to the order of admission and calling for records dated 16/2/2024, comma, the TCRS have been received. Para, let the paper book be prepared. Whereafter, the matter be listed for orders to fix a date for hearing. Yes.
Paper book is ready.
Paper.
Still. Witnesses.
For hearing. It should come up for hearing. Yes. You, Mr. Khan, you are for whom? Okay. Oh. Heard 3 I.U. Chaudhary, learned counsel for the appellant, who by referring to the order dated 24/3/2026 has submitted that the matter ought to have been listed for hearing. Full stop. Also heard 3 R. Kaushik, learned APP, as well as 3 Khan, A. Khan, learned counsel for respondent 2. You appear as a private counsel or amicus? A. Khan. Full stop. 3 Khan, the learned counsel, has, however, informed that copy of the paper book has not been received by him. Full stop. Para, in that view of the matter, let the copy of the paper book be served upon Sri Khan, the learned counsel, for the response number 2, for which he would make necessary coordination. Would submit this matter for hearing. When hearing on a date to be fixed by the registry after the Bihu vacation. Madam, you'll be appearing instead of okay. Oh, okay, Hari, will be bhiya kar dijiye, huh? Instead of RR Kaushik. Okay.
16.
There is a private respondent. POXO matter. Okay, madam, we need your input. There is a private respondent
So matter.
in a POXO matter. Okay.
Take instruction.
Howard Sri I.U. Chaudhary, learned counsel for the applicant appellant. Full stop. Oh no, full stop. No, who has informed that the objection by the state has been filed. Full stop. He has, however, submitted that there is no service, there is no report on service service upon the respondent number 2. Full stop. Miss B. Bhuya, learned addition PP, prays for some time to obtain necessary instructions from the concerned PS. Full stop. Para? Yes, madam, how much time? Matter accordingly stands adjourned to be listed on 24th of April, by which date report from the concerned PS be obtained. Report on service upon the respondent number 2 from the concerned PS be obtained.
Against you for hearing. লাগিয়ে আছে এটা পুলি পোস্ট না ঠিক আছে
Conviction under? You have gone against equity. Charge was under? Just give us 1 minute, 1 minute.
জেলে পিল ইউনিভার্সিটি অলপ খুলিব পাৰি অলপ খুলিব পাৰি
Yes, please. Yes.
Finally, for you say it was either just it was identified their cities. Well, on the time. And that was not be identified. No time to play, but and it's another picture. Then another picture, the complainant was the and some other one section 200 on the basis of the other petition, better we did.
Better? Okay.
It was completely focused.
Okay.
Ultimately,
It was registered as a complaint and thereafter it was committed. Okay.
and the other section. We go to by
Yeah, as a complaint case. As a sessions. But there was no prosecution. There, it was. But no charge sheet. Probably.
Yes.
Yeah, so a lot of the parameter that is case 5. The affair dated 16/10/2012. It was won by Samsung House in 11%.
Samsul is PW 5.
Same matter. I have honor to state that 1138 on 15/10/2008 by along with my younger brother Azarul. Attorney General son of Abdullah, that is the Nepal. The houses and Koilu, traveling to Murigaon in the furtherance of conspiracy expanded. It was number 9, 10, and 11. The rest of the appointment to the person back Azarul found from the bus. After stopping the bus at Koramani Salia, surrounded him and the inflicted severe injury to him by assaulting with bricks to weapons. In fact, circumstances, when Karul and Barul raised to offer resistance, they were also assaulted. Inflicted severe injury. About 7 million other will die at Murigaon civil hospitals. When police on the Murigaon went to rescue the injured person from a place of injured person, assaulted 10 more. If there were incidents, we found due course of division. That is substance. Some substance is there. The victim of the environment.
I along with Mahendra. He was also there traveling.
Yes.
The informant.
The Murigaon PS case number 161 of 2010.
The incident was of 15/10/2010 at 11:30 AM. Yes.
This case was investigated. That's coming to the final. This case 151.
151.
The legal portion is 153.
Charges were framed under 302, 325. So.
151. Per.
Then this portion is 154.
154, yes.
Investigate.
Yes.
Necessary as done that. Sima before. When you are daughter of the two states, was received from about 2:30 AM on 9/10/2010 and about 5 PM on 12/10/2010. The body was found at Gauhati, Haryana. This connection case was registered as the Haryana. In 4 hours, 15 days to avoid the complainant brother, Azharuddin was traveling to Morigaon in 407 minivan, along with Abu and Prince. Some people told the several others at Kodamai Banket. The 3 persons who abducted King Asima are traveling in Morigao and 407. After knowing this, people from the scientific scam sentiment and the matter played among the people who hears it. A lot of people carry there, take 20 407 bucks, and when bus arrive at Gauhati market, they stop the bus. After making other things, Bahur and Koilu, these embarked from the bar. After inflicted assault on it. Then it started with 4-5 people. Later on, it went to almost 2 to 3,000 people. Which that other things, Bahur and Koilu sustained reasonably. As a result, of assault meted out by many people. The same. Other than that, Morika's people, here it could not be established who exactly is.
No.
Because of confidential investigation, it is larger than 4-5% spread the news about the plan. And other things, Arun and Koilu were captors in Maladas. Here the names of those 5% will not be found. Since it is not certain, the names cannot be found out in future. Since no sufficient incriminating records have been found against the arrested persons for committing an offense punishment, this final report is submitted in connection with prayer made for acceptable. So that is the final report submitted by I. So thereafter, another petition was filed and complaint and was examined. This statement also you can look into that statement that is 149. Not a question of them. That's the thing that we have. Without a complete person. PCS at about 10 a.m. 15 then I while I was there, this along with Bahul Islam, other one 11:30 bus arrived at West. Full good day. There is a big number of names. Abdul Mujibur Rahman, Sulti, Nurul Hussain, Anul Haq, Torab Master, Abdul Marfot Pondo, Mustaquddin, Abdul Hamas. There is a food on the road. Stop our path. Then another 5% will take. They have to accuse Mustaq and accuse Abdul. Ask one passengers to get off the bus. At first, Abdul got off the bus. Accused was started assaulting him. Therefore, Harun and I got down from the bus after the accused person talked to us. Then the accused person took us inside the nearby rice field. Azul was also taken to the mine. The accused was got the rice field, having tied us before. The accused was assaulted us with sticks. Almost. Right? The accused person started us by about 1.5 hours. So, police arrived and took us 3 of us to Lahore. We kept that Bosala, authority trusted given. He was taken to Morika's window that night. A treatment was done. I was sent to him. That was his statement before this. Wasted. Was security. On the basis of this statement, my is proceeded by is counted to the court of session. And the court session that was pleased to see charges. That charges were also a case in. There is a case in.
H8.
These are under section 341 by 34 for his wrongful displaying Azharuddin, Koilu and Baru. And 302 by 34 for causing death to Azharuddin, younger brother of Samsul Haq. And 325 by 34 for causing injuries up to Koilu Islam and Baru Islam. all party after charges were verified. And it was committed to the court of state. And thereafter charges were framed. And there are only few witnesses were there.
No, these charges were framed by the session judge only. The
Ah.
committal order was prior to this framing of.
Session judge.
Thereafter,
We- This is the item.
five PWs.
Five units. The other one is Authorised.
He was also injured.
He said that after to clear on 15/8, then place 11. On 15/10, because of saying that was 11:38. At the time I was coming from Lahore, that was mine. All the bus arrived at 11:30. Mustak, President, Nazrul Haq, along with other spots of buses. Left me along with family from us. Just because the fact that Yama has been where 16-17% were there out of it. I should recognize our first include communication speed. Now I know what ends on the backside and the front of that markers, Nazi consensus of overtly and move forward. After 1 hour, police from the Warsaw approach arrived and the police took the state from the police. Thereafter, police from the Havila side took the two blocks to Warsaw approach. I sustained injury on my head, both legs, X-ray, Baru and Agarwal also sustained injury. Agarwal was sent to the same place with the Monaco civil. He was severely injured. He succumbed to the injury, and we are not properly treated by police. Mustak, this is another politically inflamed, or directed police not to keep it. Baru Islam myself were arrested from the cost to the place. Sent to Monaco from where we should treatment without curiosity. I will want to lights. And prosecution. The place of offense is a bus stop which is situated in the middle of my house is situated about. There was no such delegate in the community deciding in our place of offense. Further, deciding the place of offense alone. Nickel was stopped there as it is a bus stop. Person get that immediately after stopping the public. Passengers go down on a weakness. That's a bus stop. There are about 2,500 and more people get that day. Don't get that there. Or them as the lake, and there are so many which are not known to me. And so I could not recognize this person. There was altercation with the most such of it. The passengers come down to the vehicle. I could not recognize the person by the moment I had them. I have not seen the persons after the offense of the week. I can recognize them some of the persons who assaulted me. You know, remember the persons present today in the dock, whether they are assaulted me. Both from Lahore to Kolama is very easy. Person coming and going the same day. The bus stand now Lahore is a big place. We boarded the bus and there were many people are there. The distance between Kolama to Lahore is about 15-16 meters. I crossed several villages, 7 villages. There were town panchayats, schools and colleges situated in the small villages. Villages residing in the same village mostly are Muslim. Names of the persons residing in the same village are found similar. There are more than 1% in the same name of the person like teachers, doctors, etc. When the bus started, I am Harul Adar, I was stopping the bus and they were armed with that. We were suffered for immediately after getting down. We were assaulted by the person who sustained injury. We were assaulted for half an hour. People get it, they are excited. Some person under the name of some other person, the founder. But assault not to be. Thereafter, we got possibly taken to a high school. Actually, last one person get it. I could not recognize the person as I don't know them from Ali. I want to save myself after police from the law. Prior to that press, one called Yasmina from Doraimari area was the body was found at Doraimari after 3 days of Harul is found to Alpha was my family. Allegation of examining Mara was also upon along with that. We were arrested in this case and case is still pending. I do not know who filed the affair of the state. I do not know who filed the protest petition. I cannot say who will drag us out from the vehicle as there was last number of person that day. So if your lordships is cross examination and it can be scheduled to be. The examination sheet, he says,
Hmm.
he names some of the person that who assaulted.
Correct.
But in cross-examination, he says, no recognize.
Mhm.
Totally different.
During the police investigation part of the case, was there any TIP? No.
So the examination sheet, he says,
Yes.
they all kind of after 1 hour policeman. So here they, this person pushed out the past, back them off. Start president, Guru Singh.
No, see, this not recognizing, this is in the context of the rice mill.
Yes, that part.
Hmm.
Because they were following the right look.
Thereafter, we are forcefully taken to a rice mill situated near the bus stoppage. Initially, a few number of persons are there in the mill and subsequently large number of persons had gathered. I could not recognize the persons. The persons who had gathered subsequently, he doesn't recognize them. But he had recognized in the chief these persons.
That part, that was also.
No, he also says, I cannot remember the persons present in the dock today,
Yes, I think that.
whether they are the persons who assaulted me. Whether all of them are present that day. That you have to see from the order. Whether all the accused may not have been present on that day. Anyway, so. Re-examine also.
45 was latest statement before the magistrate. It is 14. That statement are already at 45. Before statement another 2 hours. Then in recourse examination, it was clarified. Names of some persons which I mentioned in the are known to me from others. You were accosted and restrained by more than 1,000 people who were assaulted. I cannot exactly say who particularly has assaulted us. Nowadays, there are several persons attending. Who don't identify the person, say they were more than 1,000 people at that given time.
What is Exhibit 4?
They told us statement on the second point.
Oh,
Because after filing of the argument, it comes PW2.
So PW1 will not help you. Even the exhibit 4, which was his 202 statement in his examination 200, he had named certain persons. In the recross examination, he has said that those persons' names I have also gathered from somebody else.
not first time.
No, he doesn't. He covered
From others.
I didn't know the first.
Because there were many persons, he said. Anyway.
Yes, thereafter.
PW2. Yes, 15.
No, on the identity of the accused persons, apart from PW1, are there anyone else?
Parul Islam. 2 eyewitnesses. Injured eyewitness.
He was declared hostile.
Hostile.
And Khairul? Jamaluddin was not there.
Khairul, PW1 is
Samsul is the informant.
He's not present.
But he said that he was in the bus.
He said that Koru and Paharu phone.
No. In the FIR,
He said, I along with my younger brother.
he says that he was in the bus.
I said, I was at home. On that day I was home. I would and see when to Monaco by the way after price is take
Samsul.
Kun?
Samsul.
No. Only these two. Baharu, PW1 and PW2.
Read the FIR. At page 5, page 5.
Yes, he says he was traveling. Informant says he was there. But it does not emerge from the testimony of. PW1 and PW3 are the eyewitnesses. Injured eyewitnesses.
PW2 doctor, what has the doctor said? He conducted PM.
He said that on the examination I found the following. A dead body of adult 27 years wearing a black hat Pakistan. Wearing don't not is found. Last stain seen in the left ear. The surface moved in the right side of the body. Eyes half open, mouth closed, which are of different. Whose position carried accelerated incision on the forehead, right side. Multiple injuries, both on the leg, injury mark on the left side of the knee. All injuries were away from. Whose position, bruise on the right part of the face, leg impression on the back, lateral side of the body. And then ligature on feet. Then the abdomen was found to be engaged. Stomach was healthy. There was no really fitness. And for other found to be. Thorax was also found to be. Multiple injuries were found in that sleeve. On the right side of the chest. The screen was the first one. Multiple injuries were found. But at that, on the right side. These are the hemorrhage and top. And also in cross-examination also gets come back. On the dimension and number of injuries, it was a case of random public.
There were Baharul Islam recorded his statement before magistrate also, but during that investigation, police investigation perhaps. It's not there. But it was that during the police investigation. Because he denies his magistrate statement.
Yes.
Then PW3, who is PW3?
He was also one of the enrollment. As for accused persons, I know the district. Offense took place about 4 years ago, that's about 11 years. I, along with Koibul, Asaruddin, would have come public from Lahore. After arrival to the past, stoppage at Gural lines, many places are located. 4 went to the check out from the family, they taken to the after the son. I could not identify the person who drag us out from the past, taking the bill and assaulted us. After taking me to the hospital, I heard the names of Subbil, Afak, Hollywood, and others from Fathers Cadet. Hollywood and myself were taken to Honda Hospital. Others were taken to Manila, who died there. I made a statement for a minute. It was there. And he said that it is not a fact. I said that we would have made that while I was up. Let me get the comment. So in the night of that, otherwise, it's not the good to say that. also say same thing, it doesn't put on persons who are in the law.
The case against them, the victims, that relating to that girl disappearance, and it was lodged by one of the acquitted persons in this case.
Open by day. Only.
Some of the accused persons.
That party was there.
The case was lodged by some of the accused persons in this case. Comment. Inshallah.
No. Rest of the I do not know. This is a third thing. No less part and I was traveling in the same bus. This is other thing was traveling from Gauhati to Nashik. When bus reached our Gauhati area, I have seen a large number of people. Bus stopped there. 3-4 buses moved entire from the bus, water district down from the same bus. This was allotted by Eastern Road. Azadi was sitting in that house inside the car. He was sitting behind me. Also, I seen someone unknown person exposed to it. I could not recognize any of the accidents. I waited, moved, and we left. I began to know that we think about the man. My step was recorded before that court, and we moved the safety. Persons who name I mentioned, they are all known to me prior to the offense. This person is a dog also not most possible assaulted as well as
Are not those persons.
Please give a clean sheet. In one of this case, I know all the this is other than my cousin. One took place around 5 years. So there was 11 cousin. On that day, I was home. Harun, Perun, and Mrs. Sakaruddin went to Morelau by again. On the way at Williamite, they accosted by a group of people who took them to the as well. After police was reached and said that Harun Harun, the city's other than what is in the incident, but taken to Morelau. One forwarded informed me regarding the matter. I went to Korea on the thing there are actually a lot of people there. And I went to Consola, and I found President and informed me regarding the matter. Then I come to Morelau Sudilo and met Azaru. He told me. I think it is a dying. He told me the name for the further namely Oilul Bhapa, Mandul, Oilul Chala, Sabir, Great Dazi, another person whose name I have forgotten. And then I find that it in Aja, and please watch me to learn where my statement was recorded. I my cousin. Another place the names are confirmed enough. It is linked to other person beside me. This is the place of how to my house. I got the name of the person from the newsletter. At the time they are not known to me. Now I come to know that they are not to us. So according to him, the deceased says owning the name of the deceased. Now this man was never sentenced to death. And his 161 statement was also not produced. So, confusion was conducted in a very powerful manner. Either 200 statement inquiry, either 161 was not important. In fact, statement. I was brought to the landed court, where my statement was I put my thumb. So there is a 164 step. So I went, what is this?
Record to some.
Apparently two oral dying declarations, kind of statements. Moreover, the testimony of the eyewitness is different regarding the identity. If they had corroborated, then of course it would have been slightly different. This is the reasoning in the impugned judgment, because of this identity.
One quality is likely the original response. This is the case of
Page.
base 1.3.
Okay.
More than that, really medical examination. There are multiple injuries found in the legs as well as the collapse. More opined that they have shock because of police. It appears from a medical response that it is used publicly. Naturally, when a person is shouted in the public by some person, it is difficult to identify the actual culprit who caused the particular incident. Because in such situation, the burden of liability of causing the incident of one after. The general tendency of the people in such situations to treat others when they are in the incident to do one, who is one of the victims as well as both fatal victims, very securely. Render a very securely. This testimony made in the examination chief appears to be very contradictory. Cross-examination. During his cross-examination, to one, accompanying the deceased at the time of the apartment. And it is supported prosecution case to great extent. But in his cross-examination, it becomes a complete contrary to his earlier. This witness was subject to re-examination as well as re-cross-examination. During the re-cross-examination, video one, there is a displayed by more than 1,000 people who assaulted him. But he couldn't exactly say who assaulted him as well as he did not identify. The accused person says there were more than 1,000. As on comparison of the testimony, people are being examined and in cross-examination, re-cross-examination. Witness is found to be most unreliable. It seems that he had intentionally made contradictory testimony of his as well as in his re-examination. Another vital witness, PWP, Authorised. He is also one of the victims that plus amount of social. He stated that though he acknowledged the deceased at the time of murder, he could not accompany the father who fled out from the bus to obtain custody. Witnesses were left behind. Our doing process, submission of witness PWP detailed. He could not recognize the father who and subsequently assaulted. Other witnesses stated that whose father who were present in court were not present at the time of murder. This witness clearly negated the presence of speed. Period 4 and 5 have not supported promotional case from India. Period 4 is evidence that he had seen some unknown persons speaking. Rule in the case not recognized to specific. This brought interpretation. Period 4 that this persons present in document not the person was something. Period 5 comes to know. Who the informant against is a guessing. You are not present in the place of offense. The deposit authority told him about the name of the accused father to be speaking. You find upon hearing it said all the data before the Oliver station. Cross-examination. You said found the names of the accused father from the institute. Simply look, CW1 court witness Samtula. Which the uncle of the informant stated that this is what he saw. He stated that you were not present at the time of occurrence. At the time of occurrence. At the incident, he also heard the incident from one Kadir, who told him that his deceased son was taken to Morigao Civil Hospital after being assaulted by some people. According to CW1, Sabdul Ali went to the Morigao Civil Hospital, saw the injured person on me, asked his son Azaruddin, told him the names of some accused person, namely Marfat, Mondal, Hibjur, Tamiduddin. During cross-examination, he did not see the occurrence of the incident. Court witness, who is father of the deceased, only heard the names of Marfat, Mondal, Hibjur, Tamiduddin from his son Azaruddin. But his son did not tell him about the involvement of the alleged incident. Hence, it reveals that none of the witnesses could lead convincing evidence so that the accused person could be brought to book. Even for the most vital witness, PW1, Khairul Islam, PW3, Baharul Islam, rendered completely divergent evidence which cannot be relied upon under any circumstances. Whenever it shall go to the accused person on the bare provisional evidence of PW1 and PW3, there is a clear reflection of mutually opposite proposition, which at variance at the earlier statements made before the police as well as magistrate. The learned counsel of both parties have put the case in so and so. So then that the arguments have been there. Your lordship will kind to come page paragraph 12. With regard to the propriety of the case, some loopholes were found to be committed by lower court, which were pointed out by learned defense counsel. As discussed earlier, the case was resulted in FR initially. But the learned court below, by rejecting the FR on the strength of the protest petition, converted the case into CR case. However, learned court below, without recording the statement of the complainant, under section 200 CRP, proceeded with the case by issuing process to other witnesses. Learned magistrate, by committing error not recording the statement of 200, relied upon the statement of complaint made during the investigation.
Statement of complainant was recorded.
Recorded, my lord. That's the wrong finding.
Anyway, sorry.
Then he says the learned magistrate committed error by not recording the statement of under section 200, relied upon the statement of the complaint made during investigation under section 164 CRPC. The learned magistrate mandatorily ought to have recorded a statement of complaint under section 200 CRPC. For such impropriety, the learned defense counsel also prayed for dismissal of the prosecution ground on the ground of vitiation of the committal procedure. This apart, the learned magistrate before whom the FR was submitted did not explain the reason and passed a speaking order, as how three more accused persons, namely Moinul, Tamiduddin, and Surabali, were issued summons and they were not named in the EJA. Then he says that under further circumstances, this court is of the view all the shortcomings of the prosecution case as discussed above. Paragraph would either give benefit to the accused person. The benefit of loopholes, either in the facts or in evidence, or in the procedural impropriety, would go naturally in favor of the accused person. That the prosecution is not able to establish the case beyond reasonable doubt. The accused persons are not found guilty. So in all the cases are acquitted. That is the judgment.
And the court directed prosecution of these two witnesses
Yes.
for false evidence. Para 15.
Para 15, man. Conclusion, man. Khoirule was the most cited witness, led contradictory evidence on whether the evidence would not reflect their intentionally made unethical testimony with the object of bewilderment in the mind of the court, and they are required to be prosecuted making assurances. Will make measurement for taking cognizance and consent. Huh? So best. Our case is basically, my lord, the case was not properly conducted in the trial court. Their previous testimonies, 164 or 200, were not exhibited in the court. My lord. Even if it declared hostile, they should be confronted with the earlier version. That was not done.
But can that be a ground for reversal of an acquittal?
Our case, basically, our prayer was for remanding the case for fresh trial. Because from the evidence, there is nothing has come against the accused persons, as I've already pointed out. It's admitted case.
No, even if we ignore those observations made by the learned court regarding non-recording of the statement of the complainant,
Yes, ma'am.
the substantive evidence is before us
Yeah, I understand.
in the form of 5 witnesses. Now, we have to make out a case that if there are ingredients in the evidence of these 5 witnesses to come to any other conclusion other than the one which has been arrived at by the learned trial court. Because the other conclusion is the conclusion of guilt, which would require a much higher degree of proof. Now, is it a possibility with this?
Yes.
That is the test we have to.
No, your lordship is correct, because we have.
Now, even if we accept your case, we brush aside the technicalities. 200 statement was recorded, that was somehow not brought to the notice. But ultimately, substantive evidence in the form of 5 witnesses are there, on the basis of which we can record a finding this way or that way. A finding has been recorded of acquittal in favor of the Mr. Barbara's client,
Yes.
which has fortified the presumption of innocence.
Yes.
Now, the burden which you have to discharge is of a higher degree. It's not a trial. It's a case where the presumption has already been fortified by an order of a trial court after a full-fledged trial,
Yes.
leading into an acquittal. To reverse an acquittal on the basis of these 5 witnesses, so we cannot enlarge the scope of having more witnesses unless you make out a case of extreme nature that witnesses were forced not to go to the court or any of that. That is not the case. This is a simple case.
No, yes, I understand. I've understood your lordship's view, my lord. But my simple prayer, what has happened in this case, as your lordship has seen, the manner in which the prosecution was conducted, my lord, those earlier statements, whether it is a 164 or 200 statement, they were not brought on record. And they were not put to the witnesses. Had they been put to the witness, either he will say or yes or no. We don't. But actually, that was a great lacuna on the part of the prosecution. But they have to have done it, but they failed to discharge their duty. As a result, as an appellant,
Let us see those. Where are those statements here?
that your lordship, I will enclose. One is already exhibited, that is 200, my lord. That
200 is there. We have already seen.
and then
Paste, where is 200?
Page page 149, my lord. Why the Khoirul, my lord.
What is that? This taking care of and doing. Registered as a complement. Once you PSM, so. Where is that 164?
164, my lord, that mostly it is in the record.
Here there is.
Do you have a copy of 164?
Yeah, one second.
Two zero two statements.
This is 164 is at 146.
I don't know, 200. 161.
Jamaluddin statement.
One plus enough. And 161 is there, my lord, that is. Page
Jamal, then we have seen that.
164.
164.
It was recorded during the police investigation.
Police business, but he doesn't name anybody, my lord.
Three or 4 years.
He does not name any.
See, the only 164 statement which would have been relevant is this Jamaluddin at page 146.
Yes, my lord.
If you read 147, his statement,
Yes, my lord.
he has not named anybody.
No,
as such.
he doesn't name anybody.
And his narration is also slightly vague. He is not connected to this Azharuddin. He says, I saw that third line, I saw the 3 or 4 youths drag down a boy named Azharuddin from the bus. I saw the youths assaulted Azharuddin while dragging him down. Later, Khairul got off the bus and went in a run towards Azharuddin asking about what had happened. Then the youths assaulted Khairul also. After that, again Baharul got off the bus. Youths assaulted Baharul also. Thereafter, youths pulled away Azharuddin, Khairul and Baharul to some. I don't know the youths, clear statement. I saw them at the place of occurrence. And so far as, if at all, 164 was recorded of Samsul. Samsul in his chief says that he was at home.
Yeah, he was out.
He was at best, he's a hearsay witness.
Yes,
And his, the alleged dying declaration, which was made before him
yes, ma'am.
by Azharuddin in the hospital, there is no mention in the
FIR.
FIR. No mention. But in 164, probably we may. Asani, we record. No?
Maybe in the.
We'll check in the record. That's it.
There's a mob fury appears to be.
Hmm? Mob fury. No, even mob fury could have been addressed, or witnesses are not consistent at all.
Not actually, it is not exactly a mock fury also. The initial the direction of the allegations is that it is a calculated attack on them to take revenge for.
Yeah, understand, madam.
Result out.
So. Okay. 164 to Salami. Where the Hon so good. Other Hon so the Hon. Other Hon Diana. Other Hon so.
Mandau keso na.
Probably phone. Logo, Louis. Phone. No, they are using police. Something is missing here. No, no, in relative. I allow it full person. What's the link to?
Let me see, madam.
Case day to also ले कौन पाएगा? Case day to उसने साले कौन?
Yes, there is that.
Is a pro. They don't know what it.
May I have
That will not. Oh, that will not play a role in the decision of the process. Also, as the decision. Full. The part of certain to decision. Say, Mr. Kotoki, if you have completed, we can hear Mr. Barbara. Anything else you would like to submit? There.
he has that from Baharul and others he has come to know.
No.
And in the English translation, in the FIR, it appears that there is some error. He
Error.
doesn't say that he was in the bus.
Yes, that.
So his testimony as PW5 that he was at home appears to be consistent
Correct,
with his FIR.
And in 164 statement also he has stated that he has come to
He has not said he has got them long question.
Yes. he has come to know from Baharul and name of the accused persons.
Okay.
And that ought to have been exhibited, madam.
Exhibiting it, will it have any Any difference in the decision-making process? Number one.
The manner in which they were this trial was conducted, my lord, Your Lordship, at least endeavor could have been made, but that was not done because by producing those 160, 164 or whatever it, they ought to have been put to the witnesses. You have stated so before the magistrate. On what basis? That was not done.
These kind of offences, from my personal experience also, I've seen
Because earlier,
some
why-
complaint cases, it's
At the
very
time of
severe handicap to, conduct the prosecution without police investigation methods. Sorry, please.
yeah, I understand, my lord. But what they on oath they have stated, that is my concern. On what basis they have stated in the oath, my lord? Huh? I said,
Reflection 164 of Samsung, information.
PW 5, page 20, what has been stated?
Regarding that other case, relating to the girl,
Lordship, no, Lordship, regarding they have taken down the bus, Lordship. It is reflected here in
that other case, suppose this is why they.
reason is for that case, Only.
So that was-
Where is it?
It is in the 164 of Samsung, Lordship, informant.
যে মারফত ইগো সফিৰুৰ আজাৰুদ্দিন খৈৰুলৰ আছে আৰু বুলি জানো, প্ৰেৰণা আছে বুলি জানো। আৰু এই বিষয়ে খৈৰুল আৰু বাহুলৰ বৰথলা পুলিচ ষ্টেচনত কয়, আৰু এই খৈৰুল আৰু বাহুলৰ মতে দুজন আছামী মুস্তক প্ৰেচিডেণ্ট আৰু লালু পঞ্চায়তত জড়িত আছে।
আমি জানাম পুৰণা
লগত পুৰণা আক্ষেপ আছে, আক্ষেপ আছে বুলি জানো।
পুৰণা আক্ষেপ।
Only that.
আক্ষেপ আছে।
He has not mentioned about that case.
No.
Doesn't specifically doesn't answer about that kidnapping. He says that about যোৱা 15/10/2010 তাৰিখে দিনৰ 11:11:30 বজাত প্ৰায় 12টা বজাত পাছত মই ঘটনাৰ বিষয়ে খৈৰুল আৰু বাহুলৰ মুখত শুনো। এওঁলোকে কয় যে 11:30 বজাত গৰৈমাৰী বাছ ষ্টেণ্ডত আগতে আছামী আৰু আজাৰুদ্দিন খৈৰুল আৰু বাহুলক 407ৰ কি নাম লাহাৰুইঘাটৰ পৰা মৰিগাঁৱলৈ ফালে গৈ আছিল, আৰু গৰৈমাৰীত আছামীগণে আজাৰুদ্দিন বাহুল আৰু খৈৰুলক বাছৰ পৰা নমাই দিয়ে আৰু ওচৰত এটা ধানৰ মিলত লৈ যায়। তাত আছামীগণে কাঠৰ বা বাটাম আৰু এটা ইটা লৈ আজাৰুদ্দিনক মাৰে, লগতে খৈৰুল আৰু বাহুলক মাৰে। আছামী আব্দুল মতলিবে বেছিকৈ মাৰে। এই মৰাৰ ফলত আজাৰুদ্দিনৰ বন্ধত বেছিকৈ আঘাত পায়, আৰু ওচৰতে কোনোবা পুলিচ ষ্টেচনত খবৰ দিয়াত পুলিচ ঘটনাস্থলীত আহে। পুলিচ আহি ঘটনাস্থলীত খৈৰুল বাহুলক আৰু আজাৰুদ্দিনক আনে, আৰু আজাৰুদ্দিন দশমিত বেছি হোৱাৰ বাবে মৰিগাঁও চিভিল হস্পিটেলত নিয়ে, আৰু ঘটনাৰ দিনা ৰাতি 7টা বজাত আজাৰুদ্দিনৰ মৃত্যু হয়। আছামী মৰফেট হিফজুৰ চাবিৰ লগত আজাৰুদ্দিন আৰু খৈৰুলৰ পুৰণা আক্ষেপ আছে বুলি জানো। এই ঘটনাৰ বিষয়ে খৈৰুল আৰু বাহুলৰ বৰহলা পুলিচ ষ্টেচনত কয়। এই ঘটনাতে খৈৰুল আৰু বাহুলৰ কোৱা মতে আৰু দুজন আছামী মুস্তাক প্ৰেচিডেণ্ট আৰু লালু পঞ্চায়তৰ ভাইচ প্ৰেচিডেণ্টও জড়িত আছে। That is 164 before doing investigation.
Okay.
Basically, our case is that if they will stick to the story made out in the Naraji petition, means while recording the complaint case, my lord, whether it is recording 200 statements, the matter would be different. And those statements were also not put to the witnesses, my lord. But later on in cross-examination, you ought to have re-cross-examination. So actually the perfunctory conduct of the part of the prosecution, these accused persons were got the benefit.
Okay.
So our prayer is that it should be remanded for trial. That is because actually there is no betrayal as it appears from the record. These are my sentiments.
Who will you hear first, Madam or Mr. Borbora?
আমার কি আছে জানা?
One of the good judgments, sessional judgment I have come across. It dealt with this, there is no any severity to remand it. Lordship will see that first of all, he, Learned Session Judge allowed recross examination. On his part, he did it. And that's it. There are only two eyewitnesses, 1 and 3, both declared hostile. And both declared hostile. 3 declared hostile. So, question is,
One was declared hostile.
one was declared hostile, that is PW3. No?
Yes.
PW3 was declared hostile. And re-examination was granted, my lord. Cross-examination. Question is, both this PW1 and 3, paragraph 12 of the judgment he has said, I will not repeat it. The learned judge has dealt with. Now, both these witnesses, PW1 and 3, were also victims. That is a remarkable thing. They were subjected to severe beatings and severe injuries. Not like any other witnesses. That is to be noted down by your lordships also. They themselves were victims, seriously beaten up by the mob. And it is that therefore unlikely, my lord, that they would testify differently during the trial in favor of the accused. Admittedly, a mob of 2,500 persons, page 12, PW1 version, page 12. I will not repeat, my lord, to say the time of the lordship of this court. What is read, I will not repeat. Admittedly, a crowd of 2,500 plus people. It is not believable that PW1 could have identified as many as 20-25, my lord, assailants, and the very statement of 202 itself is shrouded with cloud and not believable. Trial judge, my lord, clearly observed the mutually contradictory versions of the PW1 and 3. I am reading, my lord, paragraph 10 of the judgment. Paragraph 10, that your lordship will find it 134 and 135. How he dealt with it. 134, it appears. Then he discussed, my lord. When a person is assaulted, public gathering, some person, it is generally difficult to identify the actual culprits who have caused the particular incident, because in such a situation, the burden of liability for causing the incident shifts from one after another. The general tendency of the people in such a situation is to blame others when they are interrogated by police. In the instant case PW1, he is one of the victims, as well as the most vital witness, rendered very shaky evidence. His testimony made in examination chief appears to be total contradictory examination, cross-examination. During cross-examination, PW1 accompanied the deceased, who accompanied the deceased at the time of occurrence of the incident, initially supported the prosecution case to a great extent, but his cross-examination, he deposed completely contrary to his earlier evidence made before the court. This witness was...
PW1 is Khairul.
Yes, Khairul. This witness was subjected to re-examination as well as re-cross-examination at later. That is most the learned trial court could have done, my lord. That he was not a mere spectator. Law says that he couldn't be a mere spectator and kept mum. He allowed all these things. So Because even at a later stage, he allowed it. It said that the dates were different. 6 months thereafter, he did it. Thus, on comparison of the testimony made in examination and cross-examination or re-cross-examination, witness is found to be most unreliable and untrustworthy. Seems that he had intentionally made contradictory testimony in his cross-examination as well as in recross. After then another vital witness, PW3. This much has been said about PW1, who is also one of the victims in the case, didn't support prosecution in his evidence. He has stated that though he accompanied deceased at the time of occurrence of the incident, he couldn't recognize the persons who dragged him out of the bus. This witness was declared hostile by the prosecution. However, during cross-examination, this witness PW3 reiterated that he could not recognize the persons. Even then, he kept on saying. So 202 statement is overridden by all these things, my friend. Who took him and subsequently assaulted them. Further, witness had stated the accused persons who were present in the dock were not present at the time of occurrence. That is very vital. Hence, this witness has clearly negated the presence of the accused person at the PO. PW 4 and 5, there are not so many PWs. There are only 5 witnesses. The case is accused number, huge accused numbers, number of accused, but 4 and 5 witnesses. And we have none for the defense. 4, 5 have not supported prosecution case from any angle. PW4 in his evidence has stated that he had seen some unknown persons, victim Khairul at the PO, and he could not recognize those. At least he could have recognized all from his own village, could have recognized 3, 4 and named them, let alone 1819. No, he have seen no. Recognize none. That is the version. Unknown persons, victim Khairul, that the persons present in the dock were not the persons who assaulted the victim Azharuddin and Khairul. PW5 Samsul Haq, who is the informant, is a hearsay witness. He was not present at the place of occurrence at the time of occurrence of the incident.
You are referring to observations made in paragraph?
My lord, page 134 and 135.
Paragraph?
Paragraph, my lord, judgment, paragraph 10. Page 134 and 135, paragraph 10 of the judgment, my lord.
Okay.
Then, my lord, he was not present at the PO at the time of occurrence. He deposed that Azharuddin told him, the deceased told him the name of some of the accused persons, namely so-and-so, so-and-so, so-and-so. Upon hearing the incident, lost written as I had before. He is the person lost. In cross-examination, 5 stated that he found the names of the accused person from the injured. And the 2 injured person says, we know nobody. We have seen nobody.
Okay, we'll take a break of 5 minutes.
There was a court-appointed court witness, Sabdul Ali. Incidentally, he was father of the deceased. Last paragraph, page 135. Court witness Sabdul Ali, who is the uncle of the informant, also the informant's uncle, stated that deceased Azharuddin was his son. He stated that he was not present at the time of occurrence of the incident of PO. He heard the incident from one Qadir, who told him the deceased son Azharuddin was taken to Morigaon Hospital after being assaulted. Accordingly, court witness Sabdul Ali went to Morigaon Hospital, saw the injured. On being asked, his son Azharuddin told him the names of some accused persons, namely so-and-so, so-and-so, so-and-so. CW stated that he didn't see the occurrence of the incident. This court witness, who is the father of the, only heard the names of so-and-so from his son Azharuddin, but his son didn't tell him about the involvement of the alleged incident. So,
Involvement of the?
But his son, last sentence of the paragraph, but his son didn't tell him about the involvement of the alleged incident. Saw some people, but didn't say their involvement, that they were involved. So, this is also.
Prior to that, let us see CW. You have not read CW?
CW1 is the Sabdul Ali, the appellant.
Appellant.
Where is his statement?
Page 22, man.
Page 20. Page 22 is statement.
22 you have left out. 22 is also there.
Yes. Yes, this is, can I go back to page 22 for a,
Let us complete 22, that will be better.
yes,
Yes,
page 22, then I'll come back.
yes, yes.
My name is Abdullah, yes. Informant Samsul is my nephew, this is Azhar, my son. In a way, he is an interested witness, this is Abdullah. I know all accused in the dock, absently accused in the precedent of so-and-so, so-and-so, so-and-so. Occurrence took place on so-and-so at around so-and-so. At the time of incident, I was at so-and-so, 10, 11 kilometers away from the place of occurrence. Then one Kadir phoned me and told me about that Khairul, Baharul, Azharuddin were assaulted by village people. Then I got information that injured were taken to hospital. Reached there, and my son, this was second son, also reached there. I have seen the injured persons there. Police personnel were also there. Then I asked Azharuddin, told me that Khairul gave a bag to him inside a car. Actually, it should have been inside the bus, as per Khairul's statement. Then they changed the position of the, he told me that Marfat and Hizbul came in a motorbike, and then he told the name of so-and-so, so-and-so, so-and-so. Then he died in the hospital. Then my nephew lodged FIR in the petition. So he learned everything from somebody else. Then, even otherwise, this purported dying declaration told about travels in a car, motorcycle. It never said that out of that these were the 17 persons who actually assaulted him. Now coming back to in course also he said post for Oh, yes, below. So I have not seen the actual occurrence. Kadir resides about half kilometer away from my house. I have no knowledge where from Kadir made the phone call. It's not a fact that Azhar had been unconscious at the place. It is not a fact that Azhar had not stated before me that 2 persons came in a bike and didn't know the name of 4 persons. The house of Kadir is so and so kilometer. So that's all what he said. Then, my lord, coming back to page 136 again. 135. Below last sentence, 135. Court witness, who is the uncle indicated that this is Adharan was it? I have read this paragraph. Then the page 136, middle paragraph. Middle. Hence, it reveals that none of the witness could lead any convincing evidence so that the accused persons could be brought to court. The judge said. Even the most vital witness, PW1 Khairul, PW3 Baharul Islam rendered completely divergent evidence, which cannot be relied upon under any circumstance, and benefits shall go to the accused persons. On bare perusal of the evidence of 1 and 3, there is a clear reflection mutually opposed to the proposition, which is at variance with their earlier statements made before police as well as before magistrates, and that in 164. So, my lord, here it cannot be said that there was any, by simply not producing and confronting the 160 pages amounted to a separate lapse in it. The prosecution case is not always 100% watertight in any given case. The lordship's consideration will be whether there was any severity so as to remand back the matter, and I will cite a Supreme Court case on that later on. Now, assuming that PW1 had been declared, PW1 had been declared hostile, what would have happened? He, with the level of a hostile witness, would have been put to re-examination and cross-examination. That's all. Nothing more. Other man was put to cross-examination and saying both of them were victims. Side by side, they were assaulted. As minority lordship has therefore seen that even otherwise the learned judge allowed subsequent re-examination, cross-examination. Now, my lord, in this context, I am taking your lordship to page section 154 of the Minor Evidence Act. It being a discretion of the court may not or may and it nor is bound to, my lord, when it finds such witnesses discreetly. Evidence, sir? It will later.
One 154 you want to place?
154.
Yes, please.
Questions by party to his own witness. The court may, lordship may, not the word may, in its discretion, permit the person who calls a witness to put any question to him which might be put in cross-examination by the adverse party.
Hostile.
Yes. So what thereby I am meaning that it being a discretion of the court may or may not, or is not bound to, my lord, when it finds that these two vital witnesses are discredited. That's what I want to point out. And on that, my lord, I'll, on term of hostile and adverse witness, whatever we call it, the court's discretion 154 is the one, is absolutely, and he met it, my lord. In this context, my lord, I am citing, my lord, two decisions. 71, AR 76, Supreme Court 294. Satpal. Satpal. Court of Visa. There are two decisions. One lot. Yeah. Yes, ma'am, just 1 minute.
You have given one copy.
Yes, Satpal will, your lordship will go to paragraph 27, 28, 29.
Yes, Mr. Yes, only one copy, why? Two of us.
Four copies, two copies.
Yes, we have got. After that,
27. Paragraph 27.
27.
Yes. This is even actually they are witnesses are independent. Here we cannot call them independent. This takes 27, this takes us to the evidence of the independent witness P2, 3, 4. What happened in the main supported the prosecution. The leave of the court, the PP cross-examined and confronted them with their contradictory statements which they have made their inspector so-and-so during investigation. The question is, could the court validly pick out teeny bits of their evidence and use the same to support the prosecution case? Then it relied a Jagil case, my lord, submits that when a prosecution witness being hostile is cross-examined by public prosecutor with the leave of the court, his entire evidence is to be discarded as a matter of law.
But is this the law presently holding the field? Entire evidence is not.
Entire evidence will not go, my lord.
Supports the prosecution can be taken.
Yes, the part, earlier part, suppose the prosecution will take into account.
But it is not that the, my lord, he remained a mayor spectator in this case, my case also. 29A, my lord, I am reading hostile witness and adverse response and unfavorable witness. Paragraph 29.
28.
All terms of English law, common law, which of witness or things that manifest antipathy, which demand an answer cause of the party opposing. Means party was not as a general permit to contradict him with his previous inconsistent statement, nor allowed to impeach discredit by general evidence of better. This rule had its foundation on the theory that by calling the witness a party, represents him to the court as worthy of credit, and if he afterwards attacks his general character for veracity, this is not only modified by the court, but it will enable the party to dissuade the witness if he spoke against him and to make him a good witness. If he spoke for him, the meaning means in his hand destroying the credit he spoke against him. This theory of assumption gives rise to considerable conflict of opinion as to whether it was competent for a party to show that his own witness had made statements out of the court inconsistent with the evidence given by him in court. The weight of the ancient authority was in the negative. So this was a common law discussion. in the parlance of evidence, my lord. Then the other case, my lord, I want to cite. This is my lord. Pandappa. Here, my lord, I'll rely on paragraph 15 and 16. Next. 1994, my lord. This is judgment of Air 1997 Supreme Court, 3663.
It's in our letter. Or is it okay? Pandappa.
Pandappa.
No, no. Have you given 2 copies? No. Pandappa Diana is Pandappa, please, the citation again.
My lord. Air 97 Supreme Court, 3663.
97, 77.
97.
97. Supreme Court,
3663.
3663.
Equivalent is, my lord, 97, volume 10 SCC.
97, 10 SCC.
My lord, here is one. Equivalent is 97, volume 10 SCC 197. Here, my lord, I will rely on, my lord, paragraph 15 and 16. Paragraph 15, my lord, it refers to, my lord, again, Satpal's case. If in a given case, the whole of the testimony of the witness is impugned, last paragraph, quoted portion. Middle. If in a given case, the whole of the testimony of the witness is impugned, and in the process, the witness stands squarely and totally discredited, judge should, as a matter of prudence, discard his evidence in toto. Similar view was expressed in a 3-judge bench, Bhagavan Singh. Court gave permission to the prosecution to cross-examine his own witness, thus characterizing him as what he described as a hostile witness, does not completely efface his evidence. Evidence remains admissible in trial, and there is no legal bar to base a conviction upon the testimony if corroborated by other reliable evidence. In this case, there is none. Then, my lord. So it is, my lord, easier prayed than done for a remand. On that case, my lord, there is no apathy in the trial, my lord, and the learned judge, my lord, session judge, in his judgment, my lord, has taken note of everything. I will read, my lord, one more paragraph of the judgment. Paragraph 12, page 136.
Same Pandappa.
No. Panappa I have quoted and
Okay.
I left that paragraph between 16, my lord. This is impinged judgment.
Okay.
Page
Oh, the
130.
judgment. Okay. Page.
Page 136, paragraph 12 of this impinged judgment. With regard to the propriety of the case, some loopholes were found to have been committed by the lower court, which were pointed out by the learned defense counsel. As it is earlier discussed, that case resulted in FIR initially. But the learned court below, by rejecting FIR and on strength of a protest petition, Naraji, converted the case into a CR case. However, magistrate, without recording statement of 200, proceeded with the case by issuing process to the other witness. Not from those whose 200 statement was taken, all these out of this, all these accused. The learned magistrate, by committing error by not recording 200 statement under section 200 CRPC, relied upon the statement of the complainant made during the investigation, as well as under 164 CRPC. This he has stated. For such impropriety, the learned defense counsel has also prayed for dismissal of the prosecution on the ground of vitiation of committal procedure. At that apart, the learned magistrate before whom FR was submitted did not explain the reason or was speaking order as to how three more accused persons, so and so were summoned, since they were not named in the other. Under the aforesaid facts and circumstances, this court is of the view that all the shortcomings of the prosecution case as discussed in the foregoing paragraphs would give benefit to the accused persons. The benefit of the loopholes, either in facts or in evidence or in procedural impropriety. These are the three, my lord, integrated parts to see whether, my lord, a judgment is good or bad. Propriety, procedural impropriety would naturally go in favor of the accused persons. Thus, the prosecution has not been able to establish case beyond reasonable doubt. In the result, and so, hence all the accused persons shall be. And then, my lord, therefore, the learned at 14, my lord, he gave this verdict, my lord, about his entitlement of the compensation of the victim. My lord, forget about that. Then, my lord, in our trial on Air 2017 Supreme Court 804. Remand.
2000,
17 Supreme Court 804 Ajay Kumar. Equivalent is, my lord, 2017 volume 12 SCC 699. Here, my lord, I will refer to three paragraphs. Paragraph 11, 12 and 13. Yes. Paragraph 11. Copy this. That's it, got it, copy.
yes, you have just given.
Ajay Kumar Bhusa.
Yes, you have given. We have.
Then paragraph 11. Though, paragraph 11, though the word retrial is used under section 186B, Roman 1 of the CRPC, the powers conferred by this clause is to be exercised only in exceptional cases, where the appellate court is satisfied that omission or irregularity has occasioned failure of justice. I'm putting that for both your lordships. Where the appellate court is satisfied that omission or irregularity occasioned in failure of justice. The circumstances that should exist for warranting a retrial must be such that where the trial was undertaken by the court having no jurisdiction, or trial was vitiated by serious illegality or irregularity on account of misconception of nature of the proceedings, then I humbly submit this is not the case. Right. Then it says an order of retrial may be passed in cases where original trial has not been satisfactory for some particular reason, such as wrong admission or wrong rejection of evidence of the court, refused to hear certain witness or who are supposed to be heard. It's not in my case. 12. De novo trial means a new trial ordered by the appellate court in exceptional cases when the original trial failed to make a determination in the manner dictated by law. The trial is conducted afresh by the court as if there had not been a trial in the first instance. Undoubtedly, the appellate court has power to direct lower court to hold de novo trial, but the question is whether when such power should be exercised. As stated in Ukha Kohli, an order, this still holds the field. An order for retrial of a criminal case is made in exceptional cases and not unless the appellate court is satisfied that the court trying the proceeding has no jurisdiction, number one, to try it, or that the trial was vitiated by serious illegalities, number two, or illegalities, irregularities, or on account of misconception of the nature of the proceedings. And on that account, in substance, there had to be no real trial, or that the prosecutor or an accused was for reasons over which he had no control, prevented from leading or rendering evidence material to the charge, and in the interest of justice of the appellate court deems it appropriate, having regard to circumstances of the case. Here the judge never prevented the no witnesses sought to be presented was prevented. An order of retrial wipes out from the record the earlier proceedings and expose the person accused to another trial, which affords prosecutor an opportunity to rectify the infirmities. That is another consideration. Rectify the infirmities disclosed in the earlier trial and will not ordinarily be countenanced when it is made merely to enable the prosecutor to lead evidence which he could but has not cared to lead, either on account of insufficient appreciation of the nature of the case or for other reasons. This court, while dealing with the question whether High Court should have quashed the trial proceedings and on account of declaration of the legal position made by the Supreme Court concerning the procedural aspect about this case involving offense under so-and-so act, court stated that de novo trial should be the last resort, and that too only when such a course becomes so desperately indispensable. Then it cited one Madhya Pradesh case. This is because the appellate court has plenary powers for re-evaluating, reappreciating the evidence, and even to take additional evidence by appellate court itself or to direct, but to reply the whole laborious exercise after erasing the bulky records relating to the earlier proceedings by bringing down all the persons to the court once again for repeating the whole deposition would be a sheer waste of time, energy, cost, unless there is miscarriage of justice or otherwise. Hence, these said courts can be resorted to when it becomes unpreventable for the purpose of averting a failure of justice. The Superior Court, which orders a de novo, cannot afford to overlook the realities and the serious impact of the pending cases in trial courts, which are cramped into dockets, and how much that order would inflict hardship on many innocent persons who once took all the trouble to reach the court and deposed their versions in the very same case. To them, the public and reenactment of the whole labor might give impression that law is more pedantic than pragmatic. Law is not instrument to be used for inflicting suffering on the people, but for the process of justice. I conclude with this. And one thing, at page 175, ground number 4, the appel memo, it has been stated that for them the evidence of CW1, it transpired that the deceased before succumbed to injuries, he told the names of so-and-so, and therefore on scrutiny it appears accused person were involved. So no dying declaration was taken as per procedure. My lord, that is this is not that. I read his version also. So there was no dying declaration in the IFO. Only contradictory statements. Must have.
Yes, madam.
Lordship, regarding PW1, Lordship,
Yes.
there is little thing that his chief was, Lordship. His chief was taken on first day of October 2013, Lordship. Case number 11. Taken on, this is first day of October 2013. Then cross was reserved, Lordship. And cross was taken, Lordship, after a gap of 16/8/2014, Lordship.
Yes.
This is also one reason, Lordship. There is a variation in his statement, Lordship, while deposing in chief and in cross, Lordship. But Lordship, the fact remains same, that there was altercation. They were taken down from the bus, which is corroborated with PW3, who is hostile, Lordship. The names he haven't said, but who have taken them. But in PW1, Lordship, I can recognize, I'm going to. In the cross part, Lordship, in the last, there's reflected, Lordship, that Baharul Samsul are my son. My own Azharuddin was my cousin. The allegation of kidnapping and murder of Yasmin were brought upon me, Baharul Azharuddin, along with others. There's the enmity between them, Lordship. It is reflected, Lordship, that there is enmity with the accused person. As because, Lordship, in PW5, Lordship, who is the informant, Lordship? In the informant, Lordship, the last page number 20, Lordship, there I found Khairul and Baharul. They informed me regarding the matter. Then I came to Morigaon Hospital and met Azharuddin there. He told me the names of the accused persons, namely Khairul, Marfat, Mainul, Ainul, Jalal, Sabir, Hibjur, Nazru, Motleb, and so and so. I have forgotten. And one other person whose name I have forgotten. Then I find the statement, Azahar, then his statement was recorded, Lordship. In the cross part, Lordship, there are other villages in our in and around our village. The names I have mentioned might be the names of other person residing in those villages. The distance between so and so, I got the names of the person from the injured Lordship. I got the names from the injured. At that time, they are not known to me. Now I came to learn that they are the residents of different village. But there is no such suggestion that those persons were not involved in the crime. Same is with the CW1, Lordship. It is
But in the chief, there has to be an affirmative statement of their involvement.
And-
Please read, please read
and
the,
in the cross, or in the cross.
please read the chief, PW5.
He negates his chief in the cross.
Lordship. I am the informant of this
No,
case.
no, it was the last part. Then I came to Morigaon Civil Hospital and met Azharuddin. He told me the names of so and so, so and so, so and so. And one name, he told names.
He told names. Because his condition was, Lordship, he died.
No, he had told the names.
Names, only the names. Then there is no suggestion from the defense, Lordship,
No, no, first there has to be an affirmative.
that here, what
These persons had assaulted me for which I have suffered this, I'm about to die. He has said some names. Maybe these names may be the person who tried to save him also.
Lordship,
It may be possible
to
that
my understanding, Lordship, when he have asked to the deceased, Lordship, what had, who?
where have you stated?
But to my, I'm saying,
No, where is this question?
that is not there, Lordship. That
No,
is
you
not
cannot
there.
presume. If you presume, there can be a presumption.
Then I went to the.
See, you are handling a criminal case where the degree of proof is beyond all reasonable doubt. Now certain names have been stated. Now he doesn't even say that he stated that
Involved in the
they were the assailants.
sin.
So we cannot presume. They may be the assailant, but they may not be the assailant.
There is no such suggestion also that they are.
Is it required?
It is an incomplete oral declaration.
But
It's not required. The touchstone is benefit of doubt. If there is a doubt, benefit of doubt.
in the CW1 also, Lordship, he have always said that in CW1, same, Lordship. Page number 22.
CW1 is even worse. CW1 even
Then I asked Azharuddin and he told in the chief, I have seen the injured person there. Police personnel was also at the hospital.
You ask, come towards the sixth line from the bottom of the chief executive. Then I asked Azharuddin.
He told me the name.
No, he told
gave-
me that
gave
Khairul
me
gave a
the
bag. Then they changed the seats.
seats.
He told me that Marfans came in a motorcycle. He told the names of so and so, so and so, so and so. What?
Then he died in hospital.
He told the names of so and so.
Complete.
And in the cross, Lordship, that's in the occurrence.
Cross is,
Participation is
even,
not there, man.
cross is damaging.
thing is that the 164 is also not exempted. That is also one thing. 164 also.
See, 164 we have just discussed. The relevance of 164 after the matter, after the Naraji was accepted, complaint registered, 202 was recorded, that may be a perverse finding, and matter remanded back. Did 164 becomes redundant?
But
Because this witness gets a chance
to re-examine.
to depose as a witness in the dock.
No.
This 164 can be used by the accused to confront, not to build up a case. No, I had said in 164, I have forgotten here, so I fall back on 164. That cannot be. 164 is no evidence.
That is there.
No.
You can corroborate, and that can be used for confronting the prosecution witness. It's a weapon of the defense. Just like 161 you confront, 164 also you can confront.
Pencil or chip. Because not adding a few sentences, everything is gone, because it is there that nearly it is a dying declaration naming all the accused person, and that is reflected that he has enmity with those persons. But allegedly they are not named in the term it should be. But the rest I leave up to you, Lordship, because
Okay. Anything else, Mr. Ragoto?
It's from it appears that because earlier version was as pointed by my learned PP mail, 2013 while the deposition was made by PW1, after 1 year, his deposition came. Mostly it was won over.
that is most.
No. Winning over maybe at the stage of cross-examination.
Yes, that
That you cannot. Chief was there.
Chief was there, my lord.
We can proceed on the basis of chief.
Yes.
You tell us anything in the chief which forms an incriminating material to
But-
proceed.
Re-cross-examination, he has said the names of some person which I mentioned in Exhibit 4 are known to me from others.
He's nullified everything, my lord. Whatever is there. That is the problem.
No, see, that can be a two-edged sword. The last one. He has been given a chance to say 160. Don't read the cross, read the first part of the re-examination. He says about 164. Then only the cross comes.
200, my lord, yes.
See,
I made a statement before.
I made a statement.
Yes.
So 164 comes on record, then the cross-examination. That's natural.
Content was I admit the
That's
same.
natural.
Then he's saying recross
He was in fact given a chance to bring the 164 on record.
Yes.
Or that 202 statement.
But he, in cross-examination, recross-examination, he has given an explanation. I mentioned in Exhibit 4 are known to me from others. We are accosted and restrained by more than 1,000 people. I cannot exactly say who particularly assaulted us. So there he has given an explanation that that whole statement goes by. It nullifies the earlier version by.
Okay. Please write it. Heard Sri P. Kotoki. Learned counsel for the Apple. Also heard Sri Miss A. Begum, learned APP for the state. What's the Sri A.C. Barbara, learned senior counsel, assisted by Ansarkia. Is present, has represented the respond numbers. No. So accept the state. 2
1 to 17, no?
2
2
to
to 18.
18. The hearing is concluded. The judgment is reserved. Okay. We'll consider.
All right.
It is jail appeal, my lord. I'm appearing as a amicus in this
Okay.
case, my lord. Against his judgment dated 30/9/2021.
Oh, we were here. Okay.
Lord, let me turn on to the Ijahar. at
Just give us 1 minute.
my এই বর্ণালী বই How is this? If you difficult question to husband. Allegedly killed his own mother. Money? Own mother. Own mother. Start go. Me? Start go.
Yes, Mr. Karulkar.
The Ejahar, your lordship will find at page 4 of the paper book. It says, humble submission is that around 7:30 AM today, that is on 29/6/13.
What is the date? 29/6.
29/6/2013. The accused number 1 killed his own mother, Miss So-and-so, by hacking her with an axe on the instigation of the above named accused number 2. Accused number 2 is the wife of accused number 1. It is pertinent to mention here that there had been quarrel between the accused number 2 and her mother-in-law, Miss Tara Banu, from before. I therefore pray that so-and-so. The allegation was that there was quarrel between accused number 2 and her mother-in-law. That is the mother of it is accused number 1. He
Here, the conviction is against accused, the first accused.
first accused.
Second accused,
Second
acquitted.
accused had played away. She is absconding.
Absconding. Oh, it has to be segregated. The trial had to be separate. So
No,
proceeded against.
charge sheet, she was not even charge seated, the second accused. I'll come to that. My only issue will be, my lord, when there is no eyewitness, the chain of evidence, circumstantial evidence has to be there. It should not be broken.
No, that is with respect to the nature of proof against the
Accused number
against the appellant. Against the appellant.
Appellant.
You said that there were 2 accused persons.
2 accused.
The accused
police
number
did
1 and his wife, the accused number 2.
2
The accused number 2 has fled away.
played away.
But charge sheet was not submitted against her.
Not. Police
How-
has.
Center for trial. No, center for, not
No,
center for trial.
not for, but the charge sheet would be submitted. Investigation in the investigation.
but-
He was declared as
Absconder, yes.
We, I mean, he is 57.
By court or?
No, but police did not submit.
No,
Police did not submit the charge sheet.
Only court.
Charge sheet, your lordship will find a page 57. ma'am. Operating part is at 59. charges and information nature of offense so and so, so and so. The charge sheet in brief is that on 29/6/16, informant Mohammed so and so, late of son of late so and so of Udalguri lodged a written ejahat. And during investigation, since a case has been well established from the sufficient evidence against the ejahat named accused Muhammad
No,
Tahir,
no, there no materials against P2, A2,
no material
not
against.
sent up, not sent up.
Not sent.
On the other hand, since no incriminating material has been found against
Is it-
A2, it is prayed to the court to discharge her from the case.
But in the, this one, madam, she was shown as an absconder. In the charge sheet. 57.
Well, come to page.
Not sent up a file whether it could show absconder or sense.
No materials, no materials.
No material, they say.
Initially in the FIR, there were two accused,
Two-
allegations were against two.
Yes.
In the investigation, it was found that charges were against one, so
One.
one has been sent for trial, convicted.
And the two was not found. Two was
Two
not
was
found,
not
so
found.
police did not proceed against them.
No, it was no charges were framed against her.
No charges were made.
No, you are not charged sheeted also.
Not charge sheeted.
No, not charge sheeted because the material, because they say that there is no material,
No
but
material.
the material which are against, found against the accused number one is
Not the property.
my.
Second.
Okay.
The informant statement, Lordship, he was examined as PW1. My Lordship will find the page 9. Well, I'm the informant in this case. I know the accused so and so. He is my maternal uncle. The occurrence took place about 2.5 years ago. The occurrence took place at 9 a.m. Disease so and so is the mother of the Parabanu is the mother of the accused, it should have been. My house is situated at a distance of 3 nal from the house of the accused. The occurrence took place nearby our house boundary. A quarrel took place between the accused and his wife. At that time, disease so and so came there. Then the accused assaulted Tarabanu by means of an axe, causing her death. I lodged an FIR before the police narrating the incident. Exhibit so and so is my signature. During investigation, police came to the place of the occurrence and seized the axe at the place of occurrence from the possession of accused so and so. Cross-examining, he says, on the day of occurrence, I was ill and was lying on my bed. On hearing halla, I came to the scene. When I came to the place of occurrence, I did not see the accused person there. I do not know the name of the writer of FIR. I was asked to put signature on it. Then last line, my lord, the seized axe is not available before the court today. That was not produced before the court. Then the prosecution, my lord, 10 witnesses were
How much is this null and qubit?
null and qubit.
Now it's true.
I think somewhere I
Well-
found it is about
12 feet.
20 feet.
No, maybe more. How much is the null, madam? How much is the qubit?
On this we are discussing.
No, that was the Karimganj case. This is Udalguri.
Udalguri will be
It will be
different
different.
because they're
How much is the qubit? Qubit probably is a metric system. Qubit? In feet or?
centimeter. Qubit.
Mr. Bhagavati, any idea of a qubit?
It will be the circular form only, not in the.
Qubit, 8 qubit.
Qubit. not
Qubit.
Somewhere I found that this,
1.5,
huh?
1 qubit. 1 qubit, 1.5 feet.
1.5. Google says so,
Oh,
or 18 inches.
18 inches.
18
yeah.
inches.
Oh,
Mm,
their foot.
yes.
One now is equal to 8
18
qubit.
inches.
Okay, 8 into 1.5 to 1 over. 8 plus 4.
Put.
Eight plus four,
It will be about 12,
12 feet.
12 feet.
12 feet. 1 null is equal to 12 feet. Okay, 36. 36. Nearby. His house is nearby.
Nearby.
36 feet is very
Nearby. Nearby.
maybe neighbor. Okay,
The
then-
sketch map is there.
Hmm.
It is nearby. The prosecution has examined 10 witnesses, PW, including the informant, a medical officer and police officer. And none of the witnesses are, there's no eyewitness, my. PW 7, my lordship, just one line from PW 7, my lord, page 70. My accused uncle had a wife, Tayo Banu. Since the time of date of disease, Tayo Banu, the wife of the accused uncle, has been found missing.
You are reading PW?
PW 7 at page 7.
Let us complete the inseriatum. Just
My-
others,
The only issue I'd like to bring out, only issue that the chain is not there.
No, that is it. So let us complete the verification witnesses serially.
All the witnesses.
Yes, yes.
One I have read, my.
Yes, PW, who is PW2?
PW 2 is a,
Younger brother of informant.
yes. I know the informant so-and-so is my maternal uncle. The occurrence took place about 3 years ago around 7:30 AM. My house is situated near the house of the accused person.
Allah, hard Allah.
On hearing Halla, I came to the house of the accused and saw the mother of the accused lying in the courtyard with injury on her person. I noticed injury in the head of the deceased. Many people gathered the place and place of occurrence, and they told me that the accused person assaulted his mother, so and so, causing injury to her person. When I visited the house of the accused, I found so and so lying dead. Police came to the place of occurrence. And Cross is his informant is my cousin. House of the informant is situated distance about 60 feet from the house of the accused. He says 60 feet. I found the disease lying dead in the house of informant Rahman Ali. Informant's house. I did not visit the house of the accused. I did not see the occurrence. The occurrence took place around 7:30. At the time of occurrence, I was running the rice mill, which is situated at my house. So he said that the courtyard of the informant, the body was lying there.
In the house of the informant.
House of the
Not courtyard, house.
house of the
House
informant.
of the informant.
Then PW 3 is the neighbor. She was subsequently declared hostile. I know the accused who is my neighbor. I also know informant Rahman Ali. Disease Tara Banu is also known to me. The occurrence took place 3-4 years ago. I heard that Tara Banu died. I heard the accused killed Tara Banu. I was not present at the time of occurrence. Then she was declared hostile. It is not on cross-examination by prosecution. It was said that it was not the fact that I stated before 29/6/30 at about so and so. Tahir Ali and his mother Banu picked up quarrel for money. Therefore, the Tahir Ali in our courtyard killed mother with X. At the time, I was present at my house and I saw the incident. When the people raised Halla, Village people came and caught hold of Tahir Ali, and his wife fled away. I did not see the incident.
For the police statements, he was the eyewitness, but she denied.
She was the only eyewitness, but she
She was the only
retracted.
eyewitness. She
She-
told-
Earlier statement is there, my lordship. I'll come to that.
Okay, we'll continue after the break.
Is it?
Millard, if possible, Millard, item 4 may kindly be passed out.
Don't make a mention at this hour. Let's see. Oh, not quite over.
Bless you.
State. Report was given after 3 years. PW 7 says, my lord. PW 7 at page 17. Informant is my husband, wife of the informant, my lord. I know the accused who is my uncle. The occurrence took place about 4 years ago on the date of occurrence in the morning about 7 a.m. when my son was in our courtyard, came running inside the house and told me that Tarabanu, the mother of the accused, was lying injured in our courtyard. She was lying in informant's courtyard. On hearing this, I rushed the house out of the house to the courtyard and saw Tara Banu lying in our courtyard without any movement. In the meantime, the neighbors gathered in the courtyard. My husband also came. Then I came to know from the gathering people of our locality that the accused killed his mother. Our house is situated about 30 feet from the house of the accused. The accused and his mother used to live separately inside the same compound, but they had a common kitchen. I saw big cut injuries on the head of the disease caused by Dow. Police came to the scene and took away the dead body. In this regard, my husband lodged an FIR. The disease was own
Aunt.
aunt of my husband. Cross, he says, my accused uncle had a wife, Tayo Banu. Since the time of date of disease, Tayo Banu, the wife of my accused uncle, has been found missing. She left the spot, my place of occurrence. PW8 is also, we did not see anything. After returning from Gauhati to my home, I came to know that the accused killed his mother, so and so. I do not know as to why the accused killed the mother. I did not witness the incident. Nine is the police officer, man. 9 and 10. May I read the deposition? At page 19. On 12/6/16, madam, I was posted as attached officer to Odalguri PS. On the day I received the case diary of the Odalguri PS number so and so for further investigation of the case due to transfer of earlier investigating officer. On scrutiny of the case diary, it was found that the earlier investigating officer recorded the statement of some witnesses under 161 CRPC and also recorded statement of the 3 witnesses under 161 CRPC. I collected the postmortem report of the disease. On completion of the investigation of the case, I laid the charge sheet against accused so and so. Is the charge sheet exhibit so and so so and so. In cross, he says, during the course of investigation, one of the accused, Taya Banu, was not found at her house. Later, I did not find sufficient materials against her to send her up to trial of the case. And as such, she was shown as not sent up accused in the charge sheet. The informant also mentioned in the FIR the Tayabanu as one of the accused. I did not seize any article in connection with this case. The article was seized earlier by the PWT. Lordship will kindly come to page 21, PW10. On 29/6/30, the day of occurrence, madam, I was posted as IC at Sapmari outpost of Odalguri PS. On that day at 8 a.m., one so and so informed me over telephone that on the same day in the morning at about 7:30 a.m., his uncle Tahar Ali killed his mother by giving X blows at his house. On receipt of the telephonic information, I immediately informed the OC Udalguri so and so, DSP headquarters so and so. I was asked by the superior authority to proceed to the place of occurrence. I immediately entered GDR number so and so and proceeded to the place of occurrence and saw the dead body of the female was lying at the courtyard of the accused, my lord. Here it is, courtyard of the accused, Tahir Ali. And on and X was lying beside her. I saw cut injuries on the head of the female dead body. I conducted inquest of the dead body, recorded a statement of the available witness under 161. I also drew up sketch site plan of the place of occurrence. The dead body was sent for the postmortem Udalguri Civil Hospital. The accused who was apprehended by the village people was taken into custody by me and forwarded to court after arrest. In this regard, formal FIR was lodged by the same on the same day by so and so. On receipt of FIR, I sent the same to OC so and so. I conducted the preliminary investigation of the case, entering ZD entry after registering Udalguri PS case number so and so. I was entrusted to complete the investigation of the case during the course of investigation. I seized one stained with blood, 1X stained with blood, white Caesar list number so and so. PW3 so and so, they were stated before me that on so and so about 7:30 AM, Tahar Ali and his mother Tara Banu picked up quarrel for money. Thereafter, Tahar Ali in our courtyard killed killed his mother with X. At that time, I was present at my house and I saw the incident. When the people raised Halla, the village people came and caught hold of Tahar Ali and his wife fled away.
PW
The-
one is stated that the X was given by Tahir Ali.
No, it was,
But
doesn't
it's-
say that
it is
X was
missing
given
the-
by the, X was lying beside the dead body. And lordship will see, the medical report says the injury was a lacerated cut. Lacerated.
No, the inside is there. Restoration is also there. The inside
Laceration
also there.
is there.
But the IO does not say that he recovered this X on being shown by them.
It was just lying. there. And
So that could have been a crucial evidence for prosecution.
nine.
Result is in mentioned as such. Page 61. Bank.
But in his testimony, it is conspicuously absent.
All the witnesses also say that it was lying beside the body of the disease.
But this was a very, alluding to this level. So it was probably
No.
lying.
It was lying. The judgment, my lord, which I'll be relying, my lord, that has been quoted in this judgment. From page 39, your lordship, other part, earlier part, factual aspects has been very good. Paragraph 35, 35, I'm reading. At
These
page
are the
thir-
10 witnesses.
my-
These are the 10 witnesses.
my lord.
There are 10 with preemptives.
10. One of them have become hostile.
So the conviction relies upon, the conviction is based on which evidence?
Circumstances.
Circumstance arising out of what?
On what basis the chain was taken to be complete? By the learned friend.
That will be my submission, my lord. The chain was not complete because the missing link is there. Therefore, it has,
No, was
Discuss-
any forensic
No.
examination done?
that will be my second submission. It was not sent, not produced before the court, not sent for FSL.
What about the blood reports?
That
Not
is
not much. Fingerprints?
Yes, the
Nothing has been done.
Fingerprints was most crucial.
Nothing has been done.
Fingerprints on the down. and his
Nothing has been
fingerprints. If it matches,
So the linkage is on what basis?
Lordship,
The link of the
the
accused,
learned
appellant.
court has discussed it from the paragraph 35 to 35 onwards to paragraph 40. May I read?
06 or something.
Paragraph 35.
35 to 40, the discussion. During the course of argument, the learned defense counsel has raised pleas against the reliability of prosecution in the case. I have given due thought, due weight to such submission. The learned counsel has also relied on decision of Honorable Gauhati High Court in so-and-so, Boykunta Das, so-and-so. The learned defense counsel has placed reliance on the above decision of the Honorable High Court on question of proving the case with the help of circumstantial evidence. As the above decision is very much relevant for deciding the instant case. So I deem it fit to cite some of the paragraphs of the decision. The paragraph 8 of the judgment observed it is settled position of law that in a criminal case resting entirely on substantial evidences, all the circumstances are required to be proved solidly beyond reasonable doubt, and the chain of circumstances should be such that there should not be any missing link, and it should lead to only and only to the conclusion consistent with the guilt of the accused. The apex being so and so, apex court so and so so and so. Then paragraph 37, my lord. 6 in learned trial court heavily relied on the oral testimony of PW so and so so and so, that the accused arrived at the police station with a dao in his hand and made a confession that he had cut his wife so and so and so and so. It needs no mention that the extrajudicial confession of the accused in the police station as deposed by PW 23 and so is inadmissible under section 25 of Evidence Act. Evidently, neither the Dow allegedly says from the accused nor the scissor list was produced before the magistrate. When the accused was produced from Exhibit 3, the scissor list transpires that the same was shown to the Chief Judicial Magistrate on 27/9/13. After 20 days of alleged seizure, though the law requires such seizure shall be forthwith reported to the magistrate having jurisdiction. Inordinate delay in sending the seizure list to the magistrate, though the accused was produced on the next day itself, creates a doubt as to the credibility of Exhibit 3. Admittedly, the Dow allegedly seized from the accused was not sent for forensic examination. Then it is also no doubt, it is no doubt true that the failure to get the weapon of the offense chemically examined may not be fatal always if there are other evidences to substantiate the charges. But when the case is based on circumstantial evidence, the more particularly when the seizure weapon is a vital circumstance relied by the prosecution, such a failure is fatal. So in our case also, this was not produced, sent for FSL examination. Then the discussions went. After giving due attention to the above submission of learned defense counsel, it is found that the learned defense counsel has relied mostly on 3 points: that circumstantial evidence brought on record is not sufficient to complete the chain of facts to establish guilt of the accused. Number 2, immediately after seizure of the seized article was not produced to be shown by the learned seizure. 3, the seized article was not sent for FSL examination. The learned defense counsel also further submitted there is no direct evidence. The prosecution has tried to establish a case by circumstantial evidence only. Now, my submission will be the chain of evidence is, circumstantial is broken, is because of the second accused was not found or whatever, a charge sheet was not filed against second accused. She had absconded. Therefore, the chain is, cannot be established. The missing link. Missing link is the wife of the accused. That is my first submission. Second submission is the dao was seized from the side, but the wound is somewhat lacerated. And moreover, these were not produced before the magistrate and also not sent for forensic examination. And also some discrepancies about the evidences, because some says that it was on the courtyard of the accused. Some say it is in the house of the informant, or some says courtyard of the informant. These are my suggestions. Three suggestions.
Criminal trial, sometimes we should also ask the alternative question, sometimes, if not sometimes. That, if not this person, who killed? Who killed? Because the death is, homicide is almost proof. Of course, the chain has to be complete. And the wife is
PW1.
missing.
Lordship. PW1 is a immediate neighbor of the victim. He deposes, my lord, that I am the informant of the case at page 9. I know accused Tahir Ali. He is my maternal uncle. The occurrence took place about 2.5 years ago. The occurrence took place at about 9 a.m. This is Taravanu, is the mother of the deceased. My house is situated at a distance of about 3 nal from the house of the accused. The occurrence took place nearby our house boundary. A quarrel took place in between accused and his wife. At that time, this is Taravanu came there, and the accused assaulted Taravanu by means of an axe, causing her death. I lodged an FIR before so and so. During investigation, police came to the place of occurrence and seized the axe at the place of occurrence from the position of the accused Tahir Ali. On the date of occurrence, I was ill and I was lying on my bed. On hearing her I came to the scene. When I came to the place of occurrence, I did not see the accused person there. I did not know the name of the writer of the FIR. I was asked to put signature in the FIR, and accordingly I put my signature. As asked by the police, I put my signature in the scissor list. When I put signature in the scissor list at the time, the villager apprehended the accused and confined him. The scissor axe is not available before the court today. Lordship, regarding the recovery from the possession of the accused person, that was not challenged.
Recovery of the,
Weapon of offense from the possession of the accused person, which the PW1 has deposed in chief manner. That was not
was
challenged.
recovered, what was recovered, thou or an X?
Axe was recovered.
Now, there are evidence that thou was used.
Police has not said
My lord.
from him, the police, he discussed.
Police in deposition, he didn't say so, but in the scissor he says stated such. He has recovered from the possession of the accused person.
Is there any Caesar witness?
The witness is there, yes, Caesar.
See the Caesar list 61.
Informant.
Rahman Ali, that is PW1. Abbas Ali, PW2, and Amir Ali. Amir Ali is not examined.
Rahman Ali. Rahman Ali.
Here is its presence. Commission.
Abbas Ali did not mention about the scissor list.
Rahman Ali.
Yes. One of the witness, PW3, although she has been declared hostile, my lord. Lordship, but regarding the this one, my lord, that a quarrel had taken place. PW1 as well as Lordship, PW7, who happens to be the wife of PW1, also says so. Lordship, there is a quarrel had taken place. PW7 at page 17. Her son reported about a matter.
বহুত দূর ওটা। It is house of the accused to be informant. Body to be up to yes and yes. আগে রিমাইন্ড কিনে আসে তো বডি রিপোর্ট আছে কোন বই বসে আদার্স কোন বই বসে
Missing. Yes, lordship, missing link is there, lordship.
And PW2, he doesn't say that he is a Caesar witness.
Yes, he doesn't say so.
Ambassador, no reference to any Caesar. PW2. Hostile from. 3 has been declared hostile. 2 doesn't say anything about Caesar.
Lordship, regarding a cross-examination by prosecution, Taravanu picked up quarrel for money. Thereafter, Tahir Ali in a courtyard killed his mother with axe. At the time, I was present at so and so. Lordship, regarding this one, that quarrel had taken place, even PW1 also says so, your lordship. May I see my lord in 161 what? 161 of this one, hostile witness has been exhibited as at page 66.
No, in fact, that statement made by her in 161 has been given to her verbatim, which she has denied in the cross-examination of Ayub.
Ayub.
She was a very crucial witness.
Yes, ma'am.
Eyewitness, actually.
Yes,
She
page
told us that.
21, PW3, Masammat Javed was stated before me then on 29/6/13 at about 7:30 AM, Tahir Ali so and so and his mother Taravana picked up quarrel for money. Thereafter, Tahir Ali in our courtyard killed his mother with axe. At the time, I was present at my house and I saw the incident. When the people raised halla, the previous people came and got hold of Tahir Ali's wife.
As required under what was that case? Mishra or what?
Yes,
What was the name?
yes, ma'am.
Om Prakash or something? Exact thing has
Yes,
been
yes.
in she has denied.
Yes.
In quotation দিব লাগিছে।
The Tehsildar 6 case also.
Which one? Tehsildar or the
Suspicion plans. Latest,
Not
my lord,
Tehsildar.
Exact
Exact word.
Yeah.
Mishra ने की बात है। एपी मिश्रा ने की बात है।
Exact words might be missed. May say other things.
No.
Circumstantial evidence.
my lord.
We have to while analyzing those application of the Panchshil golden principles. One of them is that there should not be any alternative hypothesis. Suppose for argument's sake, it could have been the wife also because she went missing.
Yes, she fled away.
Fled.
And they were not residing in the same, although they were
Yeah.
residing in the same campus, but not within the four corners.
Mm. So because of this, actually there was an eyewitness, but she turned hostile. And forensic, of course, these cases are not investigated at that level because Only sensational cases maybe, but forensics can really help
My lord,
in the system of proof.
yes,
Fingerprints, if the, but
yes, my lord.
The scale, the inside is part mark is there.
There, my lord,
the inside one is there.
Hundred.
yes, my lord.
The membrane of the brain had got lacerated, but there was an inside wound also. That caused the death problem.
Yes.
So that's the question. If not the accused, who then? Some intruder
Yes, my lord.
or the wife? There is no other person, no other third entity. There's no evidence of
yes.
intruder. That
Yes.
is also true. But then suspicion that howsoever strong, those principles will come. But then circumstantial evidence is always challenging. So cannot substitute for proof. For proof in a criminal crime. Strong suspicion, of course.
I leave it to your lordship.
No, no,
I have
no.
nothing to submit, my lord.
No, no, it's okay. We can memorize the 5 principles by heart from our law college days, but applying them is the most difficult. Is
Court of lordship, lordship
Yeah.
sees the sketch map. Yes. he
Yes,
sees it.
ma'am.
Yes. Lordship, in the case of place of occurrence is A. Muhammad Abed Ali is the informant. Oh, no, not Rahman Ali is the informant.
G is
Rahman Ali.
Rahman Ali,
Rahman Ali.
informant. G is a across the road, my lord.
You will not go to G. There is a D also. The D is the indicates the dwelling of the informant.
Informant, yes.
So G is the extended courtyard across the road. That's a different.
Yes, what is
D,
but
in front of D also there is a courtyard. Probably in a village. There are 4 or 5 houses
yes.
in between. There's a
No, no.
courtyard. Now, A, place of occurrence has to be viewed to the courtyard. Now, this courtyard is the whose? Is it of the accused? Or
House of the accused is H.
not the H is down below.
It is down below.
It's not in the courtyard of H. This is the courtyard of D, the informant. D is the informant, right?
Yes, my lord.
Yes.
H is the.
And prove the art of the
House
informant.
of the, no, it is on the backside.
Backside of the.
It cannot be the courtyard of H by any standards. It can be courtyard of B, C,
my lord.
D, whoever.
If it is D, my lord, it's like closely like as he has deposed. Informant is deposed.
For the body lies in the courtyard of the informant.
Yes, no, that is a point to be looked into. Yes,
Can be in the courtyard of the accused person.
yes,
H.
H. And H courtyard and B courtyard does not appear to be common courtyard. If there is a common courtyard of A, B, C, E. Or not A, D.
Not A, B.
B, C, D.
B, C, D, E. Yes.
So, can we, nothing like this.
except the quarrel part. The person
What is the limits? Will you be enough?
no.
PW1.
Quarreling, PW1 is the quarrel had taken place, which has not been demolished. Vis-a-vis the evidence of this one, hostile witness, that would lordship corroborate, my lord. Cross-examination of the hostile witness.
No quarrel took place between the accused and his wife,
Yes.
according to
yeah,
PW1, not with the deceased. Then something happened. She came in between or something. maybe
And no explanation in 313 also.
very unfortunate. Matricide, like, if it is him.
Is the narration for PW1
My lord,
in chief,
yes,
as it appears as if
he has witnessed the,
eyewitness.
yes,
Because see, the operator is nearby how what are the accused in his wife? Here this is not connected. The accused was partly with his wife. Then at that time, this is Tara came. As if he is witnessing everything. Then the accused assaulted Tara by means of an X, calling her dead. I wrote the FIR, I said with the X. And this is the X.
my lord.
On the day of the withdrawal, on the day of the person, I was then I was bang on my bed on getting Allah, I came to the scene. When I came to the place of where I did not see the accused person.
So he did not see the assault.
Already
He
at
did
the
not see it. That
occurred
quarrel
moment
also
it
probably he did not see because he came late. He could not have seen.
This witness would not have turned hostile, that this case could be a case under the exceptions, my lord, because quarrel had taken place between two parties, other person.
True.
Yes.
If it was going in that direction,
Yes.
that can be there. So he did not see the accused person there. So he did not see the incident of assault.
PW1 as well as lordship PW, they are this one lordship, PW7, they are husband and wife, your lordship, Abid and Nisa, PW7, my lord.
Hmm.
Yes. Has also reported.
And this was lying in their court here.
Therefore,
And came to know from others. Where was she at the time of the incident, PW7 and P17?
Yes, 19.
Yes, 17, so I was back on my group. It was on the day of the myself, was reported came running. Or now, yes, running inside our home. In our.
My husband also came there, that means PW1 also has no place to organize.
If it has happened in their court here,
Minor,
and she, if she gives all the incident of the gathering people from the community. And then whereas she is the stuff.
my.
You left the word, you know.
Lot.
in their court.
And PW3 also related to PW1. PW3 lordship will see Jabeda Bewa, who has been turned hostile. My husband's name is Les Sadagar, and Sadagar Ali is the father of also PW1.
No, it's not, they don't know what is denied. What would be the value?
Lordship, it has to be that part, cross-examination part, my limited knowledge, my lord. Cross-examination part has to be corroborated by some other,
That is it.
yes,
See, 161 is no evidence.
no evidence.
Evidence 161 you can confirm.
Yes,
Now, once, in her examination, she said that she was not present. Then she said, then she has confirmed that, see, you have said before us,
yes, yes,
before the police that you are present.
yes.
She has denied, no, I have not said. Then,
That
then the
part,
requirement of corroboration from others.
other witness has to be there in order
And
to.
the IO.
I,
So we say that it was recorded by me. I was not present there.
He was not
If any
present.
other person is present, I saw friends of present there.
Yes, yes.
That might be
Other
the
witnesses.
So that would have been taken into account.
It's not here.
Okay, very good.
Right.
Deep labels. That's pretty long.
Compensation part probably not required, my lord.
Hmm?
Victim compensation, will not be required.
It is given by the trial court.
I didn't find it, my lord.
Who's the victim? The accused is a,
Oh, I think.
Wife is not
yes,
there.
Yes,
but his son himself,
I don't know.
there's nobody to give actually. There's nobody to give also, nobody to receive.
Nothing has been observed.
My lord. My lord. Era. I have some difficulty, my lord. After 2 weeks, maybe taken away.
Respondent number 2, legated counsel.
7 witnesses are there. My lord.
Boxo.
Pox matters.
You're slightly behind the bars.
My lord.
3 years, 6 months. First, earliest opportunity to jump up and do the case. People are waiting in line.
Then I,
And doing this.